Hello, I'm Timothy Wiseman with Ocampo Wiseman Law, and today we'll be going over a brief overview of Nevada offers of judgment. There are a couple of caveats before we begin. This is just an overview. It will not cover all of the details of offers of judgment. It will not cover certain unusual situations, and it focuses on Nevada offers of judgment. Other jurisdictions have significantly different rules for offers of judgment, and in particular, the federal rules that relate to this topic are meaningfully different from the Nevada rules. As always, if there are any questions, you should consult a qualified attorney. To perhaps oversimplify, an offer of judgment is a special type of settlement offer. If the offer is rejected and the person who received the offer, in other words the offeree, does not get a better result than what was offered, the offeror can use the offer of judgment as grounds to request attorney fees from the point the offer was made forward. Generally, the offer must be made at least 21 days before trial, though there is a meaningful exception to that we'll get to later. And an offer may be accepted within 14 days after service. If it's not accepted within 14 days, it is deemed rejected and deemed withdrawn. Accepting an offer of judgment will usually resolve an entire case, but there can be nuances to that. Offers of judgment in Nevada are controlled by the Nevada Rules of Civil Procedure 68 primarily, and cases that interpret it. As mentioned, this is significantly different from the Federal Rule of Civil Procedure 68, which provides for offers of judgment in federal cases, but with different terms to it. And it's worth noting that there was a meaningful change to the rule in 2019. The purpose of offers of judgment and of Rule 68 is to encourage settlement. However, it is not meant to force plaintiffs to unfairly forego legitimate claims, as the Nevada Supreme Court said in the seminal case of Beatty versus Thomas. To be effective under this rule, the offer must be made at least 21 days before trial, and it must be formally served in writing. Generally, unless the offer itself specifies otherwise, the offer will resolve all claims in the action between the parties, including costs, interest, expenses, and attorney's fees. In other words, unless it specifically states otherwise, an offer of judgment, if accepted, will generally resolve the entire case. An offer of judgment can be made by or to more than one party. If it is made to more than one party and it is an apportioned offer, in other words, if it is clear how the offer would be split between the parties on the other side, then it can be conditioned upon acceptance by all the parties. If an offer is made by a plaintiff to multiple defendants, it is only valid if the theory of liability against all of the defendants is in common. In other words, if they're all being accused of the same tort or violation of the same contract, or if the liability is purely derivative, and there must be an identifiable entity, person, or group that is authorized to uniformly decide whether or not to accept the offer. If an offer is made to multiple plaintiffs, then the damages claimed must be solely derivative, and much like the defendants, there must be one entity, person, or designated group that can decide whether or not to accept the offer. If the offeree decides to accept the offer, they do so by serving formal notice of acceptance within 14 days after service of the offer. If within 21 days after providing notice that they've accepted the offer, the obligated party fulfills all obligations, which is normally just the payment of the amount of the offer, then the claims can be dismissed instead of judgment being entered. If not, then the court can enter formal judgment upon which later execution or collections can be taken. If the offeree does not accept the offer within 14 days, it is automatically deemed to be rejected and withdrawn. This, as we'll get to shortly, can lead to possible penalties depending on the full circumstances. If an offeree rejects an offer under this rule and then fails to obtain a more favorable judgment, the penalties can apply. Under those circumstances, the offeree could not recover any cost, expenses, or attorney's fees, and may not recover interest for the period after the service of the offer that was rejected and before judgment. The offeree must also pay the offeror's post-offer costs and expenses, including expert witness fees. Under some circumstances, the offeree might also be required to pay the offeror's post-offer attorney fees. This rule allows for multiple offers, and in that case, the penalties run from the date of service of the earliest offer rejected for which the offeree failed to obtain a more favorable judgment. Notably, that part is a change that happened in 2019, and cases decided before 2019 would address multiple offers differently. When determining whether or not the offeree obtained a better result, the question of how to determine cost, expenses, interest, and attorney's fees in that consideration can be a little nuanced. If the offer provided that cost, expenses, interest, and if attorney fees are permitted by law or contract, then attorney's fees would be added by the court. The court must compare the amount of the offer with the principal amount of the judgment without inclusion of cost, expenses, interest, and if attorney fees are permitted by law or contract, attorney fees. If a party made an offer in a set amount that precluded a separate award of costs, expenses, interest, and if attorney fees are permitted by law or contract, attorney fees, the court must compare the amount of the offer together with the offeree's pre-offer taxable costs, expenses, interest, and if attorney fees are permitted by law or contract, attorney fees with the principal amount of the judgment. This can be a nuanced topic, and if there are specific questions, you should discuss them with your attorney about your exact case. Now, courts have considerable discretion in determining whether or not to award attorney's fees that are based upon an offer of judgment. In exercising this discretion, the court should consider whether the plaintiff's claim was brought in good faith, whether the defendant's offer of judgment was reasonable and in good faith in both its timing and amount, whether the plaintiff's decision to reject the proposed offer and instead proceed to trial was grossly unreasonable or in bad faith, and whether the fees sought by the offeror are reasonable and justified in amount. As mentioned before, generally, an offer of judgment to be valid must be made at least 21 days before trial. The exception to this is making an offer of judgment after determination of liability. In other words, if you go through part of a trial or a partial motion of summary judgment and the court has found that there is liability but not in the amount. In that case, the offer may be made within a reasonable time that is at least 14 days before hearings to determine the amount of liability, and then it would be treated as a valid offer for purposes of this rule. Of course, the real questions around offers of judgment are should you make them and should you accept them. When considering whether you should make an offer of judgment, you need to consult with your attorney about your specific case. Every case will be different. With that said, the answer will usually be yes. Unless we reach a very early settlement, I almost always recommend that my clients make an offer of judgment. The risks are relatively low, so long as you would be content if the offer of judgment that you're making was actually accepted, and it has potential benefits when it comes to asking for attorney's fees and determining costs after the trial. Because of that, it usually makes sense to make an offer of judgment in a case. Now, the real nuanced question is determining the timing and amount of an offer. Those are very nuanced topics that need to be discussed about your specific case with your attorney. But as to timing, my general position is that after everyone has made their initial disclosures in the case, in other words, after the very first step in real discovery, then it makes sense to at least look at whether you want to make an offer of judgment. At that point, both sides have some idea of what the evidence is going to be in the case, and that's normally enough to make at least a preliminary offer, especially under the new version of the rule after 2019 that makes it relatively low risk to make multiple offers. Whether you should accept an offer of judgment is very specific to your case, and it's hard to provide any general guidance on that, except that of course you should consult with your attorney and that when doing so, you should consider the possibility of the impact of the penalties for rejecting the offer on attorney's fees and costs. This is especially important in a case where the attorney's fees or costs might be large in comparison to any actual judgment. Thank you for watching, and if you have any specific questions, you should consult with your attorney.